Hello, happy Thursday, July 16th, 2026. This is going to be a combination of everything. It's going to be a combination of Nicole reads her latest court filing, part 3, I guess, and do not poo-poo this alert, part 3, in one video. Um, so the history so far is that on July 5th, on July 3rd, I filed something with the Supreme Court of the United States, an emergency application for a stay. I'm trying to, stop the lower court in Superior Court of California, County of Los Angeles, from moving forward with an unauthorized courtroom where I believe the other side is engaged in judge shopping. And they're really, really trying to transfer my case to a courtroom where the judge can just stamp. It's a weak demur on their part, but he'll just stamp it, and then the lower case is just killed, or I'm stuck in appeals, and it's a mess. So I'm trying to avoid that as much as I can, and in the process of doing that, I was able to unearth actual crimes committed by court clerks over there in the highest levels, like the court clerks of the presiding judge of the civil department. So, and then I appealed that, and then I appealed that rejection from the appellate court to the Supreme Court of California, and they are just sitting on it. Like, I have strong evidence. It's not even circumstantial. It's absolutely irrefutable evidence of at least 4 felonies being committed. I have and that's with the help of AI. Google AI has been helping me. Google AI is my big AI now. I'm using that almost exclusively. I think it's better than all the others for what I need. So we've been making a great team lately. Thanks to Google AI, and also it's like the two of us together. It's not like, and I'll explain that in a minute, some examples that of us working together to produce some nice stuff. But yeah, so blah blah blah. I filed that with the Supreme Court because the California Supreme Court remained silent. So I filed it with the U.S. Supreme Court, and while I'm doing all this, it's traveling by mail, because the Supreme Court is the most corrupt, unfortunately. The United States Supreme Court is the most corrupt with regard to filings being done in paper by mail. The only reason any court in the entire world is doing things by mail and by paper these days is to have an easier, first of all, create a gateway for people like pro se litigants, for instance. We have zero access to any kind of e-filing or access to the Supreme Court. Whereas as a pro se litigant, I now have so much access to every court, state, even the federal court, the lower district court, the federal. The only problem in all the courts I've been dealing with is now the Supreme Court of the United States, forcing me to print out all these copies and actually mail them in. It's very expensive, it's very slow, whereas attorneys have a little bit of a faster access, but everybody still has to file things in paper, and it's just to be able to manipulate the documents. They won't be able to manipulate documents of as much longer of attorneys filing things, because they'll be filing things in digital and paper format. But for pro se litigants, they could still doctor anything they want, do anything they want. There's no paper trail. It's at their discretion, whatever they do with it, file it or not, and it's just horrible. So that needs to change. Blah, 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 blah. Before I go into all this, I really need to because this is going to go on. I'm going to keep talking for 2 hours, because I'm waiting for something to happen right now in the lower state court. But long story short, okay, come here. Here comes the cat. Sorry, guys. This is mostly, what is this? We're into this for a few minutes now. How long has this been going on? I was going to start at 4 and end at 6. But I mostly want to tell Kelly I mostly want to say this is the do not poo poo this security alert for tomorrow. Possible security alert. I'm waiting on some stuff, but I while I'm doing all this, okay, so long story short is it finally arrived. Here it is, actually. It's good news, actually. Um, I was just saying in my previous videos, I was talking about, well, I filed it on July 3rd, even though I was aiming to stop a hearing on July 24th, and you're saying, wow, that's so early, like you got to give the lower court more chance. And it's like, no, because look, it took me forever to mail it there, and I got lucky because they received it on, according to the United States Postal Service priority mail tracking, the USPS package arrived in Washington, D.C. on July 9th. But ever since the anthrax scare over 26 ridiculous years ago that they're still doing this, every single piece of regular mail that comes into Washington, D.C. to go to any government buildings gets screened, and it could take up to a week, 2 weeks, sometimes 3 weeks, depending. They take it off site, they screen it with all sorts of radiation, and then it has to sit for a while and blah, 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 and it could take 3 weeks. It could have taken 3 weeks for this mail that I sent in to go through all that screening and then arrive in the received stamp at the Supreme Court 3 weeks from now, after the July 24th deadline. I have no idea, and it's horrible, and they do that on purpose. They do it as gatekeepers. It's like, well, politically come in, the gay whatever, the gay court clerk looking over all this will say, well, do you have a husband or a son or a boyfriend that might stick his penis up my anus? I mean, pretty much that's it. Or for the infantophile in charge of this, is there a redheaded young baby nearby, like your own child or somebody where I could have access? Or that's what the gatekeeping is here. And fortunately, either some emails I sent or somebody from the outside listening to my requests got this through that process where they could have sat there for 3 weeks. But the good news is they received it, docketed it the next day, and it shows up online. On July 10th, you could actually go to the court site and get it. And there it is. It's stamped. It's just here's the website for it. SupremeCourt.gov, docket PDF. Here's the whole website for it, and I have the link to it in the comments here, I think, in my description at least. And then they assigned it a case number, 26A50. Great. So unfortunately, I have an appendix that is 102 pages long that did not show up here. Unfortunately, you have to pay or do something, or it's a big deal. You can't have access to it. But I guess the most important thing here is my Exhibit B, which is 60 pages long, from 6 to 66 in the appendix. And that you still don't have free access to this. Pretty soon it's not going to be this way, you guys. But while everything is this, I submitted online. So I submitted a PDF file. It's there online. It wasn't paper. And it's a PDF file. It should just be up somewhere and made available immediately. But there's all these gatekeepers and this kind of stuff, and it's just BS. That's not going to last very much longer. The entire court system, every single filing, should be immediately made available to the public for free. Every court across the country. Okay, I mean, this thing where, we have to save space? Are you kidding me? Storage is like the least expensive thing on the planet. There's no excuse for this except for, gatekeeping, as I said. These pedophiles and gay men and gay Nazis and the regular whatever, blah, blah, blah. All right. So, I don't care. I'm just going to keep talking. This is for you, Kelly. I'm just waiting on something before I give you some advice on tomorrow. Tomorrow is Kelly Clarkson, my boo. She has her first show in Las Vegas, and I didn't realize this until yesterday. So I had a heart attack because I have for the longest time, I don't know why, maybe because my court date is also July 24th, the one I'm targeting, and I thought they set it on that date because that was her first concert. I don't know what I was thinking, but I always thought in my brain that her first concert in Las Vegas was on July 24th, next Friday. So I'm la la la, even yesterday or the day before, I'm watching rom-coms because I just felt like it was time to sit and wait for a minute and not do anything. And then I find out yesterday she's in the stage tomorrow. So I had a brain kind of an implosion, and I was just going to post a do not poo-poo this immediately. But then I kind of settled down and I thought, whenever I have a brain fart like that, it's a subconscious thing. Everything is done with timing. And wow, the timing on this is just incredible though, baby girl. So, okay, let's just, okay, so this is filed there. And on July 10th, it's up there. I didn't even know this until Monday the 13th. It was there all weekend and I didn't, I don't know what I'm doing. Okay, and I'm doing other stuff. But then it was denied on July 13th, on Monday, after I had found out and filed some things, and then, okay. But the denial is okay, everybody. It's like, it's not what you think. It's not a bad thing. It just means it isn't, there's a couple of things. It means, and I agree, because it was filed a lot sooner than I thought, they're just saying there's time for the lower court still to do something about it until July 24th. That's all they're saying pretty much. And so it's fine. It's still alive and well as far as if the lower court doesn't behave and we go to July 24th afterwards, or even before then, I might be able to still file something that says, look, they're still ignoring this. And so this is what I did. In the last hearing, this is for you, Kelly, please listen to this. I know it's going to be a couple hours long and it's already 15 minutes long, but this is just for you right here. And it has to do with your first thing tomorrow. Now, you know I don't like to set off any kind of panic, but I want to give you the exact right advice on tomorrow's security, depending on what happens today. So, in one of the videos I did an analogy. It was an okay analogy. I said, well, here, I'm going to refine it. There is a wasp hive or a beehive, and it's sitting there, and you just leave it alone and it's okay. Kelly is kind of standing right next to it, very close to it, and she can't move away from it. Okay, she cannot slowly move away from it in any way. What I don't want to do is start jiggling or poke at the beehive so that the bees come out and attack her. Okay, but on the other hand, there's somebody behind me who isn't nice, who's going to purposely, if I don't do something one way or the other, they're going to purposely, do something to the beehive to hurt Kelly. Some bad actors. Okay, so I decided last week, while there's time to make sure this plan works fine, I'm going to cut down the entire hive. And it's going to fall into a pit, and I'm going to cover over the pit, and we're done. So there's no fear from somebody behind me shaking the beehive, and there's no fear from the beehive itself, and Kelly is safe. And she's especially safe because if this plan doesn't work and something should happen, I have other contingencies before her first concert. That was my theory, all right? And that was when I thought her concert was still a week away from this Friday. Now, I went on, okay, so they denied the case on Monday, and I'm using the analogy, but I really want you to pay attention, baby girl, to what's going on right now. So the U.S. Supreme Court denies, thankfully, very quickly, like you need to do things quickly because I need to react quickly to this beehive one way or the other. Okay, so they didn't chop down the beehive. Fine. Okay. Now I chopped down the beehive Monday afternoon before 5 o'clock. I filed something called an administrative notice of, okay, so I did something. I chopped the beehive down myself. I tried to. Let's just do this, actually. We're going to change the analogy right now. This is going to be a better analogy. I'm sorry, baby girl. Just try to follow. Please, please try to follow, because it's going to inform you of your decisions coming up and how secure you feel tomorrow. And I don't want to make you feel insecure, and I don't want anything to happen to you either. I just want to inform you. Okay, so there is a building that has been condemned. It's very dangerous. It's a tall building, and it could fall at any time. And Kelly is a building right next to it, a smaller building very close. Now I'm the demolisher. I want to bring down that building before somebody does it wrong or before the building falls on her. So she's in danger. She cannot move. She's a building. I'm focusing on that building. And what I did on Monday was, I am the demolisher, and they can do this with high precision, and I'm trying that. So when they push down the little thing that says it's going to implode and it's ready to just whoosh and just be safe, and she's just still standing there nice and safe. Okay, I did that on Monday, and it was a filing. It was a filing I did on Monday, and I went, but there's a delay, and I'm waiting for it to go through to see if it's going to be a safe demolishing. Okay? And they haven't, so that's the analogy. And this is what happened on Monday. All right? This is what happened. I did a filing, and this is another thing I meant to tell you, Kelly, is if you do not have a lawyer who is totally 100% devoted to following the stuff I'm doing very closely for your own protection legally, but you're also for security reasons. You need to have a really good lawyer, not some whatever who's doing this part-time or whatever it is. Every filing I do now, in the lower courts filings I've done, I serve you directly through Catherine Carson at CAA through an email I'm going to show you. Every single filing I've done in the lower court has been served on you, and you have it this way. When I get up into the appellate court and all the upper courts, like the California Supreme Court and the Supreme Court of the United States, I can't really quite do that. I can't use this mechanism. It's because it's just the way the system works. I guess I could just email it to you, but an official service is what I've been sticking with. And I'm just hoping that you or somebody just from my videos or attorney is following everything I'm doing at the California appellate level, the California Supreme Court, and the U.S. Supreme Court, from me just announcing it. Okay, and I announced it to you just recently, and I'll show you. But okay, so I filed something on I filed two things on Monday actually. Monday, and it was already accepted. It's a notice that there was the filing in the United States Supreme Court, and you were served that. Okay, so your attorney, or I'm going to say Catherine Carson, was served an official document. Now that doesn't mean you were officially served. It's not legally. It's not binding. It's just courtesy copies. I'm just doing a lot of courtesy copies right now. You were not a party in that. You're not a party in any of this, actually. So these are not official services of any kind legally. It's not binding that you don't have to respond. But I am doing this to keep you in the loop of what's going on and everything I'm doing so that you can protect yourself legally and protect yourself with security, like physically. Okay? There's a lot of bad actors going on here. So this is what I'm waiting for. Is I filed the first order came through, and you have that, and if you're not, the other thing is if your attorney or you are not receiving regular filings and things on the lower court for me that I'm serving, especially even though this was served on you, it's just the court hasn't accepted yet. But if you're not receiving that from Cat, you need to consider just canceling tomorrow, because that's just not, you need to consider canceling tomorrow. Okay, if you are not receiving notices from Catherine Carson at CAA, she is or nobody's written me back saying, please do not send here, we're not forwarding to Kelly or anything like that. That means there's a gay guy monitoring that. There's a gay guy at CAA monitoring her emails and keeping these emails from her to get to you. And that is, you need to cancel tomorrow's concert if this is what's going on. I mean, that's my advice. Okay, now you have to take into account all your information, but that's a huge red flag to me that you're not receiving these, especially this one that I'm going to show you. So I use One Legal. It's fantastic for pro se filers. I have a fee waiver so I could file these things, and I don't abuse it. I'm just, filing stuff. But here's an order that is in progress, meaning it hasn't been accepted yet and file stamped in the lower court. To all you attorneys out there, and Kelly, you need to get your attorney to listen to this because this has to do with tomorrow. So right now, as of right now, there's an order that I filed on Monday evening, last Monday, okay? And here it is. Here's the order. Okay, so it's a filing I did. And I filed it on Monday evening at 7:42 p.m. Eastern Time, which is 4:42 p.m. Eastern Time in California, where it's received in the court there. And there's proof that it went all the way through. It's in progress. And I have never, out of all, I'm going to say 4, 5, 6 dozen filings I've done here over the past year, and several different lawsuits or whatever it is, it has never taken the court clerks over there in LA County to return it. They either reject it because there's a problem, or they return it file stamped, meaning they've accepted the filing and is now on the docket. And when they do accept it, it's going to be file stamped with this date, not the date that they accept it over there. So it's going to be file stamped 7/13 at 7:42 p.m. at the top. I'm talking about file stamped. That's fine. It's just that they've never taken more than 48 hours to do this. It's usually within the first 12 hours, 24 hours. Rarely, once or twice, it's gone to around 48 hours. As of tonight, at 7:42 p.m. Eastern Time, it will be 72 hours, and they still haven't responded to this. This is what I filed, was me pushing down the explosion to get rid of that building that's very dangerous, and it hasn't. And I'm waiting to see if there's a clean acceptance of this and a filing of this filing on the docket, at which point that's the beginning of the clean implosion. Right now, the implosion is not clean because the court clerks are freaking out, figuring out what the hell to do with this. And if they're freaking out and they're going to go to another level of corruption and cover-up on this filing, that means the next level of cover-up is to do some harm to you tomorrow. Okay? Like, they need to accept this tonight. And if it's not accepted by tomorrow, I am 100% going to scream from the mountaintop that you need to cancel tomorrow. Because these are the same people who are connected to people who murdered Brandon as my number one witness at the time. And now you are my number 2 witness to some really bad stuff, possibly, that I do not need. I do not need you. They just don't know this. But they're like, so you are a huge witness and you need to do some shit or whatever it is. I'm going to go through it right now. Tell your security people what's going on. But that damn filing needs to be file stamped and on the docket tonight or tomorrow before your concert, or I'm going to be sounding alarms. And I've just been sitting here all day waiting for it to be file stamped, watching the docket. And I'll show you what this filing is right now, okay? And the attorneys will understand this. So here are the recipients of it, by the way. And I mailed this to you. So Amanda Wong and Sharon Liang are the official attorneys on here for Young versus LAPD. So I have to serve them. That's the respondent attorneys. That's LAPD attorneys. The other ones are just courtesy copies. Courtesy copies go to the court counsel for LA County Superior Court. That is the respondent for all my appeals that our upper level. And there's a reason I'm doing that, because if they are corrupt, this is a trap, not a trap, but I have a full documented history of every single one of these filings. So they can't claim they don't know about this. Okay. Lawrence P. Riff and Teresa Baudet, they are real parties of interest. They are not a party to the lower case. So this isn't an ex parte. This isn't unallowed. This is allowed. And I'm directly informing not them. They're probably not even getting this, but their court clerks, because I believe they're court clerks, not to, but Department 534, absolutely. These are the court clerks that are doing all the crimes, and you're going, well, why are you serving them? Because I believe almost 100% that Trump and super high level people have been on top of this a long time, and I do poke the bear here to make them commit more crimes. So I don't understand what's the big deal in showing the bait and keeping them in the loop so that they can go commit more crimes? I mean, they're being monitored, I believe. So it's not like, oh, you need to keep it away from them. It's like, no, here's what's going on, and you're in trouble, and you need to either make a forced error or do something. And I didn't mind doing this before when I thought you're damn. I thought you're damn. I'm almost like, it's almost risky a little bit here, and I wouldn't have done it, except I brain farted, which is okay. It's okay, because my subconscious is really good at this, though, baby girl, on timing and everything I do. This is no mistake that I just panicked a little bit, but I'm okay as long as I inform you today of what's going on here. Okay, this is where I served you. It's Catherine Carson. This is it's not even a legal person or anything. It's just an agent of yours, that CAA, that I believe that I've been sending emails to for, almost a year now. That not sending, I only sent one directly from my account. Everything else has been officially like served with everybody else like this. And this is actually possibly on the doc. Like, it's a legal document, though you are not legally required to be served. It's a courtesy service, because you are the petitioner on you are officially the petitioner on the underlying CHRO case. Okay, so it's just a courtesy service. I do not serve Ed McPherson at all this, okay, because I think he's been keeping stuff from you, and I think he's horrible, and you need to really distance yourself from him. And then there's an email for the actual LA Police Department, the CPR unit. I'm not sure. That's also not an official, but it's a courtesy notice, because it could be their attorneys over in the LA City office are not informing them of all the news going on. There's a lot of corruption going on, and I just want to do a blast email. It's just a very good tactical thing for somebody in my position fighting administrative corruption. Okay? And then I serve myself to make sure what it looks like when it comes in and everything like that. So this was all sent on. So you got notification of what I'm talking about here. Your attorney should have notification, and he should be able to see the security risk I'm talking about. Okay, because what I just did, as I said, is I just there we go. Okay. So this is the actual document, and it's not file stamped yet, which means it's not on the docket. It's not officially. They could still reject it. And then I'm kind of like, oh no, for any reason. But they do have to give a reason. I'm kind of trapping them. So this isn't file stamped. I'm waiting for it to be file stamped. But Google AI helped me with this, but it's kind of trapping them in a way. It's an administrative notice and renewal of demands to the presiding judge for supervisory review pursuant to California Rules of Court Rule 10.603. This means that if he has notice of crimes or other things being committed in anywhere in the LA, in the California, the Superior Court of California, County of LA, anywhere in there, any of his court clerks, judges, whatever it is, if he is informed of potential crimes, he must investigate it. And I did, and I also gave notice of the Supreme Court case, which means you can't ignore this. Once this is docketed, it's like it says this is going to be investigated, but they don't want to docket it. That's why they're taking so long. They don't know what to do, and they're panicking. And part of the panic right now could be go get some witnesses and keep burying it or whatever it is. Okay, so I'm putting the hearing date, no hearing date, Department 222, which is Honorable Sergio C. Tapia II, the supervising judge. He is above Riff, who is the supervising judge of just the civil division. And it's Riff's court clerks that are behaving very badly. So I'm going above his head to the highest I can get, highest level of the largest whole court system, possibly in the world, but definitely the United States, definitely in the state of California. Okay, so this is big stuff. This is nothing to be accusing them. He needs to do the investigation, whatever it is. He needs to investigate the crimes that I have presented the evidence of up here. Let me read this right now. And as I said, if you did not receive this, and if your attorney does not recognize the significance of what I am doing here, when I say I'm blowing up the whole thing right now, it looks innocuous. It's just 2 pages. I don't ask for anything. I'm cool. I call myself an applicant, I think, throughout. Oh, no, petitioner. Okay. My next filing, I have another filing that comes on Monday if they don't do anything. But petitioner, I should have said applicant because I'm just kind of dipping in from up above. I'm saying I'm not a petitioner here anymore. But petitioner Huguette Nicole Leung hereby submits this formal administrative notice and renewal of demands directly to the presiding judge of this court pursuant to California Rules of Court Rule 10.603 to formally report a structural breakdown within the Civil Division Administration and the parallel escalation of this record to the federal judiciary. Number 1, High Court case institutionalized. I should have put this in bold. It's okay. Take notice that on July 10th, 2026, the clerk of the Supreme Court of the United States officially processed and docketed petitioner's emergency application under case number 26A50, the complete historical record of sequential database tampering, backdated ledger stamps, and domain mismatched vapor certificates generated by the lower court clerks is now a permanent part of the active federal high court archive. I'm saying this is serious stuff. Prior clerical subversion on June 23rd, 2026, petitioner submitted an emergency ex parte application addressed directly to the presiding judge, Tapia in Department 222, seeking forensic data preservation and a stay of all proceedings due to malicious back office log manipulation. Rather than delivering the file to executive leadership, Civil Division administrative clerks unilaterally subverted court protocol by routing the application directly to Department 833, the exact department whose foundational calendar authority petitioner was actively challenging. This unauthorized routing operated as a constructive denial and forced an immediate procedural withdrawal to avoid an unconstitutional waiver of structural defects. 3. Administrative demand. Petitioner is not moving this court for judicial relief. It's not requesting a motion calendar or entering a general appearance. Because when you do that, it forces them they're going to reroute it to 833 again. I'm not doing any of that. They have to file it as I filed it. Petitioner enters a special appearance strictly to demand that the presiding judge execute his non-delegable administrative duties under Rule 10.603B and Rule 10.6C4C. This is where freaking Google AI, I go look this up, and he's the one. I would never have found this, or it would have taken me a while. Well, not never. Nowadays, I think starting about 2 or 3 or 4 years ago, Google was actually pretty good at finding these laws, though. To interpret this file, duties under this: to interpret this file, investigate the underlying clerical record fabrication under penal code, that is a crime, sections 132 and 134, and freeze all unauthorized calendar proceedings, which is what I asked of the Supreme Court, and they thought it was legitimate enough to docket it. They don't docket everything. That was a big deal, and they did it very quickly, and they denied it very quickly. Meaning I'm doing what they wanted me to do. Go back one more time and see if they can do something before July 24th. That's what I'm doing. And I have all this. It's going to look great if they don't do anything. It's going to look great in the writ coming up, especially if the Supreme Court, which also got notice of all this, everybody's got notice that there's something going on in the Supreme Court. So when I do my writ and July 24th comes and goes and they still haven't done anything, I'm all set to file the full writ. So it's all okay. It's just dangerous right now because they're still behaving off script. They're still looking like they're trying to cover up stuff. Now, the other reason, petitioner stands entirely on the written federal and state high court record and objects to any further processing of this void action by the civil division. So, boom. This was submitted. It was served on all you guys. It's still sitting there. They usually file stamp it and put it on the docket the next day or within 48 hours, 72 hours. That tells me two things is going on. One of two things. Baby girl, okay, tell your lawyers this, or your lawyer should know this automatically, actually. Okay, and if they don't fire them, you need to get somebody who's going to hire me. Okay, no, because I can't. Well, okay. Get a freaking attorney that doesn't need to be explained what's going on here and how dangerous it is for you. All right? One of two things are happening. The notice finally reached some non-corrupt, high-power people there, like Tapia or whoever is not corrupt, and they have launched an investigation before they do anything. And the next order that comes out, this is going to be file stamped. I kind of doubt it. But with an order that says, okay, there's a stay, there's an investigation, blah, 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 and then it triggers a whole domino effect. The Supreme Court comes in on it, and then there's nothing anymore. The U.S. Supreme Court has done everything it needed, which is just to come in and say, we're watching. Stop doing things behind and pretending like you can hide in the little corner, you little cockroach. Okay, okay. So they can't hide anymore. I don't believe, unless the corruption reaches the U.S. Supreme Court. And if the court clerks up there are in cahoots with the court clerks down here, there's nothing much else I could do about it, guys. I'm exposing all this stuff. But, I mean, that's all I could do. Well, there's more I could continue doing. It's okay. And I'll talk about that later. But, that's all. You got to take it philosophically and say, okay, at least I'm making them expend energy and I'm exposing more and more and making them weaker as we do this, okay? But that's the first thing that might be happening, and that would be great. The reason they're taking so long is it finally hit the target somewhere, and they are actually investigating what they should be investigating, which is all the crimes that I've reported, okay? And they're doing all that before they actually file stamp this. I don't know, and I don't think so, because they would have file stamped it and then did the investigation. The fact that the court clerks are keeping this from getting on the docket and getting the attention of the supervising judge means that they're planning or they're plotting or they're trying another cover-up of some kind, like a huge cover-up, and it could be through Adam Schiff commanding shit, okay? And if it's Adam Schiff commanding stuff, he's like, okay, well, next thing we're going to do is we're just going to murder Kelly Clarkson, and then a lot of this shit goes out the window, he thinks, but it's not true. Doesn't matter. Okay, so we're going to get on. It does matter. It matters to me. I'm just saying there are some people out there who are under the impression that this whole thing rides on you, baby girl, as being a witness now. They've already killed Brandon, my number one witness because he was the number one person doing some of this stuff, not all of it. Okay, so there goes one witness on a lot of this stuff, but they've been committing their crimes on their own. Okay, so it's just very dangerous right now. Until this is file stamped, I think it's dangerous. And if it's not file stamped by tomorrow, you need to seriously consider, if you're feeling not safe, you need to seriously consider canceling your show. I know. And the reason it's especially not safe is you did this last year and you don't want to repeat this. So then they know that. So it's going to be that much more dangerous because they know there's a high level now before you cancel. And for that very reason, you need to cancel at a lower, you need to cancel like right now if you feel even just a little bit weird. Okay, so we're going to go through why you should feel weird and what I filed recently. So I'm still waiting for, that's what I filed. It should be file stamped. It should have been file stamped 2 days ago. So I'm watching today. I'm going to be watching while I'm talking this whole time. We're going to come back over here and see if it's been accepted. Well, I don't know who I'm talking to because I haven't uploaded this video yet. But I'm just showing you what I'm doing, baby girl, and I'm showing your attorneys what I'm waiting for and what the big deal is. So, come on, baby. So it's still there, okay? It's not. It's just sitting there, and it's the court clerks, and it's the same thing. It's like the silence is deadly, baby girl. The silence is deadly. Like they either need to reject it or accept it. The fact that they're just holding it in limbo is the worst, because that means they're waiting to try something else that illegal, including murder or harm or whatever it is, to me too, or my family or whatever. I mean, I have stories that I could put out here as well. That's like, oh my God, if I go in to get my tooth pulled, are they going to like sticks? I mean, I'm not going under. I would have canceled if I were going under from what some of the stuff that's been going on. But I'm just going in with an innocuous, supposedly needle to numb, and then they pull the tooth here actually. But, who knows what's in that needle if they're really desperate, depending on who's giving me the needle. And I still will walk out if it's a gay person giving me that needle. I'm just telling you guys. I'm telling my dear dentists, if it's a closeted gay guy with a needle, the way it was for my second vaccine shot, by the way, I should have walked out on that. It's like this gay guy, and I'm going, oh, crap. And then I'm on my butt. I mean, whatever it was not innocuous. Whatever they gave me, okay? So anyway, okay, I'm going to keep this open, and we're going to go directly to something right now, which is, we're going to read that part. Okay, so I just switched, it's Nicole reads her filing. Here it is right here. We're going to go to where we left off, and I'm going to read a section and then explain what's going on here. Okay? So I read this part in part 1 and part 2, okay? I read all this, like on, this is July 5th, part 1 I read, part 2. Part 1 was actually more, like I didn't even start reading until part 2, I think. I was just doing a lot of background stuff. But let's go on. And I made it as far as facts of the case in part 2, and then I had to get to work. I have to make a mad dash to work again this time. So, facts of the case, we're going to read on page 10. Anybody can go find it. It's right here. It's online, except for the appendix, which I will read later. It's very important too. I hope your attorneys should be able to get a hold of it, of the case in the Supreme Court. But we're going to do it right now. Facts of the case. Okay. During a hearing on January 30th, 2026, applicant. Sure, you guys like my ringtone? I loved it. I just like, you go through when you get a new phone and you see what they have for default ringtones, and then I heard ring, 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 ring. I laughed so hard, and I still laugh at that. It's like my favorite ringtone. Did you guys hear it? It's hilarious. Ring, ring. Anyway, okay. I love humor. So, during a hearing on January 30th, 2026, applicant alerted Judge Teresa A. Baudet in Department 508 that applicant had detected evidence of apparent judge shopping across all her related cases in both state and federal courts. And I don't have the appendix right now, okay? However, I did, just so you know, I do cite a lot of court transcripts here. And I did have this transcript here, but I put the full, by the way, just ahead of this reading, I put the full transcripts up here. Here it is. It's called 4 Court Hearings from January 30th. Let's come look at this right now, actually. So, all right. So everything I'm citing right now in the Supreme Court case, I just put out the full video right here. And this is the first video, actually. I'm talking to Judge Baudet and deal with this case. But now, it might not be a waste of time if I could have... So that's Judge Baudet. This is LA Court Connect. I'm the last person there. I videotaped everything because there's no... I knew there would be no transcripts available. I knew that ahead of time. They have a very big crisis going on right now in LA County, and it's purposeful. Again, because the swamps are imploding and they just don't want any kind of transparency or accountability or anything. And they're just off the wall right now with stuff. And I knew that there would be some, and I predicted it here at this she's such a good judge. So I had sat, oh my God, I had sat the day before for like 2 or 3 hours watching her take care of all these other cases, and it was the most fascinating day of my life as an attorney. She was fantastic. I trust her implicitly, and I told her that she was first chosen. It wasn't. I tried to. There's some things where she cut me off, but you could tell in the transcripts I'm trying to tell her certain things and other things. But I eventually, you could tell from the full hearing, I was telling her that they were going to try to take her off the case because she was a good judge. They were going to try to transfer the case to somebody who was a Loyola Law School graduate or of Jewish heritage or both. And that's what I was trying to tell her this whole time. Not the whole time, but I was telling her all the background of this. And I told her about Laura Wasser, Samantha Spector, and it's just very incriminating because exactly what I'm saying on January 30th, 2026 at a hearing is my predictions exactly happened. Okay, right now I'm fighting a transfer, unauthorized transfer from her courtroom, Department 508, to Judge Lipner, who is an adjunct professor at Loyola Law School and of Jewish heritage. Okay, and he's not even a Ritz. It's so obvious, and the chances of that happening randomly were like 1 in 10 million. I'm going through this with, and that was without even, he might even be gay. I don't know. I can't find a video of him. But if he's gay, it's like 1 in 5 trillion because the other, like Wesley Sue is gay, and Hofstede, one of the appellate judges, is closeted gay. So all the male judges on my cases are closeted gay. Okay. So if he is closeted gay in addition to being Jewish, and I couldn't do the closeted gay stuff with any of the AIs, they just will not, they barely did help me with the Jewish thing. I had to, anyway. Okay, so this video I just posted like a few hours ago just to support its 4 court hearings from January 30th to May 28th, 2026 in support of the SCOTUS case that I'm just reading right now, Young versus Superior Court, and 4 of the 9 hearings held in Huguette Nicole Young versus Los Angeles Police Department, CPREA unit, case number, and that's the lower court case, Superior Court of California. You can go to the docket there, and it costs money. You can only do the first page, but if you have a little bit of money, you could download absolutely everything I filed in here. And your attorney, Kelly, who is following this and protecting you, should have a copy of all that, and including the ones I've served. I mean, you could do either one, but if CAT is not forwarding this to you, then you got a problem at CAA, security risk. Okay, case number and this. So here you can go to, here's the first one, and it has the, and then here's the second one, and all these transcripts in here are in the ex parte application at the lower court that I'm talking about. So this is all available, all the transcripts I did. Now, I was very careful never to put official transcript or anything like that. This is not official. What I do is I took the one transcript that I actually bought for whatever it was, money, and I did the best I could as a pro se person to sort of copy that format and make sure I took out anything that made it look like it was official. Like there's a lot of official stamps at the bottom, and there's official stuff all over it that says official or shows that it's official or something. And I took all that out, so it's really obvious. And all I said was verified transcript. I verified that I did the transcript from my best recollection and notes. And I didn't mention that my notes happen to be a verbatim recording of the hearing. And I'm not going to admit that. I'm admitting it here outside of court, and they can come and get me But this is the only evidence of the transactions. There's no official transcripts of any kind of any of these hearings, except what I just did here. So good luck in that trap, trying to say that this is all illegal, that I recorded this stuff. Anyway, so I just wanted to put that out there, that while I'm reading this 507, we're doing okay. So here are the facts of the case. And okay, so when I say here, during a hearing on January 30th, it's right there. The entire hearing is up there on YouTube.
Ring, ring,
And the entire...
ring, ring, ring.
Okay, you're going to have to go to a voicemail. The entire hearing is on YouTube, but I also did a very careful transcript of it from, Google AI, whatever, did the transcript, and I formatted it and made it as best I could a verified transcript according to me, and I verified that there's no other transcripts. This is secondary. I did the best I could, and here they are. And then I filed that in an ex parte, and the ex parte application in the lower court was I'm trying to get it incorporated into my appellate filings, but it's a hard thing to do because that whole ex parte is 165 pages. So I have to do all sorts, it's so problematic. It's so frustrating, but I think I was able to get various clips of it. Okay, so these are the full hearings. This is the first time 2 or 3 of the hearings are actually put up on a video. I think only 2 of them have been put up in YouTube. One of them is buried within another video somewhere. But all 4 hearings back to back, boom, in one video right there. And this just to support this stuff, if anybody questions what's going on here. So during a hearing on January 30th, you can go check it out. Okay, applicant alerted Judge Teresa A. Baudet in Department 508 that applicant had detected evidence of apparent judge shopping across all her related cases in both state and federal courts. Applicant had observed a distinct pattern that all her judges were either tightly associated with Loyola Law School or were of Jewish heritage, or both, just like the 2 main defendants on her federal case, high-profile celebrity divorce attorneys Laura Wasser and Samantha Spector, both graduates of Loyola Law School, both of Jewish heritage, and both of whom applicants suspected of being behind the judge shopping, the fraudulent issuance of a CHRO, a civil harassment restraining order against her out of LA County Family Court in January of 2023, and the 190 days, I think it's 195, but 190 days of false imprisonment in LA County Jail on one nonviolent misdemeanor charge of breaking a court order. I hope we can get as far on this case eventually in the next decade of revealing that this is the longest time a nonviolent single misdemeanor charge of breaking a court order spent in jail ever in the whole history of the largest jail system in the country, in the world possibly. I think I broke a record. I mean, I'm in there for 195 days. I mean, the longest of, even if they pled guilty of it or not guilty, whatever it is. I mean, they never gave me a hearing on this. And it's the long. If you went to the mental court, if you pled guilty, if you pled not guilty, it doesn't matter. It's the longest anybody under any circumstances have spent in that jail on one nonviolent misdemeanor charge of breaking a court order. Like, seriously, this shows the level of politics behind all this, and the level of the power of the person, the people doing this. And the reason I suspect Laura Wasser and Samantha Spector is because they have tight ties and are very powerful with both the family court and the mental health court there. Okay, so they know what judges to do, they know what public defenders to manipulate, whatever it is. And all my public defenders had like Ukrainian accents, so you could tell they were like, you do what we say or we're going to ship you back to Ukraine. It felt like that. It felt like they had Ukrainian accents, all of them. So that's what it felt like, and it could be, that's why it's probably Ted Lieu who's behind some of this, and Adam Schiff, because they're, especially Ted Lieu's connections with, like, anyway, let's just go on, hiccup. As a result of the, okay, so applicant, okay, I have very long sentences here, sorry. Some of this you could tell is my writing, and some of it you could tell is Google, because it's a lot better when it's Google, but I like my voice And you could, and I like the pro se thing, even if there are mistakes and even if it's like grammatically and it's not quite professional. I prefer a mix of the two, and I don't like it when he says, okay, here's the more professional sounding, and the whole thing is, I like my voice here even if there's mistakes and it's not real professional. It's just better, I think. Fraudulent issuance of a CHR against her in LA County Family Court on January 23rd and imprisonment on one nonviolent misdemeanor charge as a result of the fraudulently issued politically motivated CHRO. Okay. And I have the Exhibit B petition is all the transcript stuff. I put little excerpts in the petition because I couldn't fit the whole all the transcripts. Unfortunately, it's just there was an exhibit limit. 5:13. We have 45 more minutes. This is going to go fine. What applicant did not reveal at the hearing was that she had. I tried to. You'll see that the judge cut me off when I was trying to tell her this stuff, and that's fine. She didn't want to go on with this. She used no nonsense. I loved it. Like, just stop wasting my time. And she let me talk for a lot longer than she probably should have. She's very patient, but I think it's because maybe it was an interesting story I was telling. I thought maybe when I re-looked at it, but I was also a little bit rude, I think. But I mean, not rude. Like, even just starting, I said, "What are you doing?" I said, hold on. Like, what the? I'm sorry about that. Whoever's out there, it was like my first hearing. Like this kind. I've been before judges before and I do okay, but it was kind of odd in that the day before as well, I was having trouble with the electronics, and what I didn't want was her to say, "Are you there?" and then she can't hear me, and I'm going, "Okay, somebody, court clerk, whatever, hold on, do not cut me out, I'm here." And that's what I meant with it. Hold on. I didn't want me to be cut out because I was having electronic problems. So that's what that was. But it's like, don't hold on. You're telling a judge, hold on. And she was very patient. You notice? Okay, what applicant did not reveal at the hearing was that she had elicited aid from various AI systems the night before to calculate conservative estimates that revealed that the chances that Judge Baudet, a graduate of Loyola Law School, was randomly assigned to her case was about 1 in 10,000. So they judge shopped Baudet. It should not have gone to her, possibly. It probably should have gone straight to writs and receivers. I don't know what they do there. Though I do know from AIs that all the judges there can and do hear CPRA petitions. It's not like CPRA petitions automatically go to writs and receivers, especially a straightforward one like this one. She is perfectly capable of deciding this. It's not anything special, and a lot of other judges do this all the time. They know the laws, and they adjudicate this very easily and professionally. It's not like, oh, it requires a special judge. No, the writs and receivers are actually very different what they handle than just, this thing. Okay, so it's just a dumb excuse they're trying to make to get it out. I knew as soon as they found out, like I did, after I finally got things served, and they found out she was not a buyable, she was not bought, and that she was not corrupt, they were going to try to transfer it out of her. And that's exactly what they did. Because I have a very long history of having corruption go against me, then judge shopping. I have had so many cases in front of whatever that criminal cases, it doesn't matter. Every single judge I've had has been shopped, and I have proven it online for the last 20 years, actually going back to my Agron case from 1994. That was judge shopped twice and rigged and whatever. So it's okay, everybody who don't want to believe this. It's okay, because it's going to focus on your family, do whatever. Not everybody has to believe the corruption for it to go away, and then life will be like you never even missed it. Like, it'll look normal 20 years from now, but it's going to be a lot more peaceful and a lot better, and a lot more problems have been solved without anybody realizing what the hell just happened. Major shifts going on in the judicial branch. And it could happen almost seamlessly without everybody knowing, except me and a few other people, Applicant told Judge Baudet that once bad actors discovered she was a good judge who could not be bought, they were going to try to transfer the case out of her courtroom and to a judge who had strong ties with Loyola Law School or who was of Jewish heritage, or both, in yet another attempt to curry political favor with a shop judge on the case. Now, did I say this exactly? Go look at the damn thing. She stopped me a couple times, but it's very obvious that this is what I was after. During a hearing on May 13th, 2026, Judge Baudet issued what applicant considers to be the last legitimate order from the last legitimate department of jurisdiction for the trial case. So that hearing is also up there. It's the second hearing posted, okay? And what the order was there were 3 future hearings spread across 2 different hearing dates. I didn't do this right. It was a consolidation of 3 future hearings spread across 2 different hearing dates set in August and September of 2026, and she consolidated them at my request into 2 hearings on a single advance date of July 31st, 2026. So why are you doing a demur and setting it in September? The other side did that. It's because they're going to lose the demur, by the way, or something. I don't know what they're doing, and it was just a mess. And I said, if you could bring it up a lot closer, let's get the demur out of the way so we can get moving on this. I filed it in November 7th, okay? Judge Baudet showed no signs of requesting a transfer of the case out of her courtroom or otherwise voluntarily giving up jurisdiction when she ended the hearing, addressing both parties with, "We'll see you then." So go look at it. Go look at the hearing. Tell me that she's acting like a judge who is actively requesting that the case be transferred. Okay, maybe, maybe not. Well, we'll see a little bit later. From May 19th, 2026 to June 8th, 2026, 5 court hearings were heard on this case in either Department 508, Judge Theresa A. Baudet, or Department 534. And departments are courtrooms, and I described that before, but I have a footnote on it earlier. When I say department, I mean courtroom 534, and then each courtroom is presided over by a judge. So the courtroom number is usually attached to a judge who's been there a long time. Or Department 534, Judge Lawrence P. Riff, the presiding judge of the Civil Division of the Superior Court of Los Angeles County. So it's the Superior Court of California, County of Los Angeles, and I called it that in the U.S. Supreme Court because that's kind of like the official term. But in everything else, I always call it the Superior Court of. They actually call it LCAC or something. They even have an even bigger abbreviation for this court, but that's it. And 2 hearings of which were unnoticed, closed backdoor hearings. So there was a lot of activity, not even a week after that last hearing. And it was triggered by a lot of stuff I filed that was evidence, where I filed a proposed stipulation that said I will offer immunity to everybody in the civil attorney's office and everybody in the court clerks, whatever, if you just give me the person who lied to you, you people, TMZ. Because there's an article in TMZ that I'm after that says, according to the city attorney's office, Nicole, blah, 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 and that was a full bald-faced lie, and I need to find out if the city attorney lied to him or if TMZ pulled it out of their asses. And if the city attorney lied to them, I don't think they did. And if they did, then TMZ, well, whatever. I just need to find out what happened. And I don't care whether the city attorney, if there was corruption, well, anyway, never mind. Let's just go on. I just need to find that out. I don't care. I'll give immunity to everybody. I'm after TMZ. They're my number one defendant over there. And it was a stipulation. I said, I'm not going to sue any of you guys. You can do whatever the hell you want. And that's a pretty good stipulation, but that triggered it. I filed that stipulation on like May 16th or 17th. I think it was the 17th. And then on the 19th, they just went crazy over there. All the court clerks just started doing all sorts of illegal shit. So why would you file that stipulation showing exactly where the crimes are? It's like, I'm doing this. I'm like, just go. Let's go. Because they're going to try to bury this anyway. I might as well poke at them. And, let's do it. Let's do this. Let's start exposing all the crimes and shit. What a conflict of interest, by the way, that there are crimes obviously committed by city attorneys, especially when they got up in front of the courtroom and stated a lot of shit that was false at my, anyway, okay. During this time, a total of 8 orders attempted. During this time, from May 19th to June 8th, a total of 8 orders, court orders, attempted an unauthorized transfer away from Judge Baudet in Department 508 to either, quote unquote, Judge Joseph Lipner, a professor at Loyola Law School who is of Jewish heritage, with a 1 in 10 million chance of this happening randomly, or, quote unquote, the Writs and Receivers Department 833, or it said both. Like, for example, it will say Judge Lipner in the Writs and Receivers Department 833, like together in one sentence. The latter of which, that one, Judge Lipner in the Writs and Receivers Department 833, the latter of which made no sense because Judge Lipner presided over Department 731 at the time and had never heard a Writs and Receivers case prior to these orders, according to the AIs. They said he was never there before, and it doesn't look like they don't have any kind of indication that he's a trained Writs and Receivers, and he's in Department 731 according to them. So he's either there or he was moved there specifically to take my case and kill it. Either way, all 8 orders are attached here to Exhibit C. Not one of the 8 orders was legally served on applicant. That is like, everybody says, oh, well, who cares, service, wait, it's a technicality. No, in this case, it's more than a technicality, because it's a systemic thing that they do so that they can do corruption at any time. It's like requiring paper to be filed instead of electronically. The only reason I caught all this, by the way, is because of the electronic footprints left everywhere. If we were still doing paper, all of this, they would have gotten away with all this. I wouldn't have been able to do any of this stuff. So the electronic, people say, oh, it's so easy to manipulate the electronics. Yeah, you can manipulate it, but it's a lot harder to get away with it, is the point. Not how easy it is to change things. You change things, but you can't get away with changing things. That's the main point, and why the Supreme Court should freaking go directly, immediately, yesterday to all electronic filings and allow pro se's to do that as well. This is crazy. Anyway, okay, I'm going to rant on this later when I do some other stuff. I still have 30 minutes before I stop, or whatever. So on June 16th, the appellate court summarily denied the request. Oh, sorry. On June 9th, not one of the 8 orders was okay, so after the June 8th order came through, the final order for the final hearing, on June 9th, 2026, applicant filed an emergency motion for temporary administrative stay and to compel correction of the trial court record. It was a mess. It was just a mess. I had already, okay, you'll see at the hearing. You'll see at the hearing on May 28th, actually. Anyway, I don't have the hearing in here. On June, I didn't mention it here, I mentioned it later. I had 2 hearings. After May 13th, I had 2 hearings on May 28th. On June 16th, 2026, the appellate court summarily denied the request from June 9th. And on June 23rd, 2026, at 10:23 a.m. Pacific time, in one last-ditch effort to give the trial court a chance to take accountability and correct the record ahead of a petition for review in the California Supreme Court. Now, you have to show that you really tried everything you could to solve the problem below before you start going to appeals, but I almost went overboard too much here. Appellant filed a appellant. Should have said petitioner. Appellant, that's fine. Appellant, I was an appellant at this point, filed a 165-page ex parte application for immediate stay, segments of which are attached hereto as Exhibit C. I couldn't file the whole thing. I'm still not able to get the full 165-page ex parte application in the system to be officially accepted, even though I'll show you why. Despite several warnings and notices given during the process of filing via One Legal, as well as on the caption page and the first thing written on page 2 in the introduction, stating that the ex parte application contained evidence of criminal misconduct by court clerks in Department 534 and Department 833, and must not be routed to any other court except Department 222. Okay, the Honorable Sergio Tapia the third, and it's the second, presiding judge of the Superior Court of Los Angeles County. The case was nevertheless routed to Judge Lipner in Department 833, the very department the clerks were attempting to effect an unauthorized transfer. Okay, so the court clerks they're doing that right now. And this is what I'm talking about, they're still doing that and thinking they're going to get away with it. What are they going to do now? They're desperate. Okay, 10. On June 23rd, 2026 at 8:39 p.m. Pacific Daylight Time, appellant felt forced to file a notice of withdrawal of ex parte application for immediate stay to avoid the due process trap presented to her and to preserve her right to challenge the unauthorized jurisdiction of Department 833. So the writing here is all AI, but the argument is all me. Like when you go to Google, he'll say, oh, well, you should file this and that. I said, no, if I file that, then I'm giving jurisdiction to 833. So he understood once I said all this, and then also I said the court clerks were going to do this, and like just the strategy is me initiating it, and then him, once he finds out what's going on, taking it the extra mile and showing me different options I had that I didn't know I had. So together we make we're just freaking unstoppable, I think, because of the combination between the two. He could never kind of do this on his own with somebody who isn't an attorney, who hasn't been to law school and doesn't understand the history that I've had with court clerks and understand the corruption and understand the law a little bit. And then you combine that with his expertise in computing. Like he had me going through and finding all the evidence I needed, and he knew the different dockets and their whole, like the way he's talking to me is like a computer expert. I'm going, okay, and he would say, well, there it is right there, just take a screenshot of that or do this, and I'm going, oh, okay. And then once he explained it, I understood, but it was like, holy cow, I never would have been able to deduce that crimes were committed from the dockets I was showing him. And he knew exactly which ones were manipulatable. Oh, he calls it malleable. Okay, that was his term, meaning they could be easily manipulated versus the ones that were more difficult to manipulate. I didn't know the difference. So once he gave me that information, I just love Google AI. On June 23rd, I'm going to settle this with Google very quickly. They have the largest market cap of everybody I'm suing, over 4.5 trillion. And because they definitely are definitely complicit, and I have an email from them saying they made mistakes. So, but you can, just this is going to be so easy because I love Google so much, and that's too bad. It drives freaking everybody, including Trump, crazy. I think he already made a deal with them anyway, because he knows I love Google. Thank you, Google. And thank you for Trump for telling Google to put all my whole website back up. I would never been able to do any of this if my whole website did not come back up last May. So that could have been Trump behind this. I mean, I'm not an idiot. I understand it's not all me and I'm not all alone, and there's some things I should be really thankful for. Even just like a lot of stuff, like the job and my apartment and, a lot of stuff. And and there's some things that financially I'm financially this, but man, it could be much worse if it were not for certain things. Like they could put me in jail for some of the, for the filings that I do on my taxes. Like, okay. Oh, go ahead, put me in jail. I'm just saying, I recognize that, anybody out there. My dearest Wordle muses, which I will talk about pretty soon. So I had to so this caused the problem though. So I'm the one who said we need to retract this because I cannot go to that hearing. He says, well, you go to the hearing and then you object. And I said, no, I mean, he understood he's very good once you tell him that this is not normal and I'm trying all this stuff and I'm my own attorney, so I can do whatever the hell I want. And that's the other thing is, I mean, if you're with another attorney, they're not doing any of this because they have to do whatever's politically and financially good for them, and they're not even taking this case. So on June 23rd at 8:39 p.m., appellant felt forced to file a notice of withdrawal of the ex parte application to avoid the due process trap. And the due process trap is if you don't show up at the hearing, if you don't show up at the hearing, well, if you show up at the hearing, you're in Department 833, you're giving them jurisdiction and you can't fight the jurisdiction anymore. If you don't show up, you lose the ex parte and possibly the case. So I had to withdraw the whole thing because they didn't send it to the right court. And the other reason is that court did not have the power anyway. The lower court has no power to give me all the remedies I was requesting, which was, put a stay, investigate the crimes, do this stuff. Only the supervising judge of the whole court can do this. So it had to go to his department, and they're just steering it away from him. And they possibly are still doing that right now. Kelly, tell your attorney this or whatever. I mean, this is very important. It looks like it's all localized little petty fights going on, but this is huge, okay? It's huge as far as your security, and it's huge as far as unearthing corruption right now on a really deep level. On June 23rd, appellant felt forced to file. Okay, so I withdrew it, and that causes a problem because it's still on the docket. You guys can go to the docket and buy it. It's going to be expensive. It's going to be $80 or something. It's like 50 cents a page or something. You can buy it and everything, and it's there. But because I withdrew it, it's kind of a gray area whether the appellate courts are going to recognize it if I just cite it as the lower court filing. Okay, because I withdrew it. So whether that filing comes up on appeal automatically or not is questionable. So I kept trying to insert it in upper level stuff, and I couldn't. One time, in the California, in the California Supreme Court, they have an exhibit length limit, and then you get to the U.S. Supreme Court, and they don't have an exhibit length limit, but they have they require you to file everything by paper. So if I have to file a bunch of copies of everything, it's costing me hundreds and hundreds of dollars to do copies of 160 pages. So I'm just like, whatever. I did the best I could, and it was still very expensive even without the 160 pages. All right, 534. I'm gonna keep going. This is all okay. We're getting to it. I promise. I'm only going to go up to page 20. Let's just get through it. On June 26, 2026, appellant filed a timely petition for review. I just withdrew it and said, okay, that's it. I withdrew it with a notice of withdrawal that said, I'm just going to file. This is called a constructive denial. It's as good of a denial. It's counted legally as a denial when they do this to your application. So my ex parte application as the last ditch effort was denied. And I still had the 10 days within the denial here from, this is the important denial, was this one on the 16th. So I had until the 26th, of course. I wait till the 26th. I just tried and okay. So on June 26th, appellant filed a timely, by a few hours, petition for review in which she was unable to submit the full 165-page ex parte application due to exhibit length restrictions. Okay, fine. So on June 27th, appellant filed a 3-page motion for judicial notice with the California Supreme Court to ensure that the ex parte application that she was forced to withdraw from the trial court that contained irrefutable evidence of crimes being committed by the court clerks would be officially entered as part of the docket for preservation on appeal and is attached hereto as Exhibit E. So it's just saying, look, I just need you guys, you have an exhibit length limit, and I need this exhibit. It's important. Please just take judicial notice of it. It's a harmless. They freaking grant this like water. It's not a big deal. And yet they had it's still yet to grant it. And my stay, everything. They just completely frozen over there at the Supreme Court. Whatever. As of 4 p.m. Eastern Time on July 3rd, because I'm here and I'm trying to get it to the July 3rd is the Friday before the 4th of July. I want it to be a gift. It's also a week after the filing here. I wanted to give them a week to do something. That's plenty of time, by the way. June 26th is a Friday. They had all week to do something, and they did nothing. Okay, so I filed on July 3rd with on July 3rd, the California Supreme Court has remained silent on both appellant's request for an immediate stay of lower court proceedings and appellant's motion for judicial review to make sure irrefutable evidence of crimes being committed by the court clerks is officially entered into the record. At approximately 4:30, a half an hour later, I was all set to go. Petitioner mailed. I got on my bike with all these copies on my backpack and got to the post office and spent way more money than whatever. Petitioner mailed this emergency application for immediate stay via USPS priority mail, and here it is. Okay, so here are the arguments. I'm almost done. I'm only going to go up to 20, and I'm going to stop at 6 o'clock maybe. The 3 independent baby girl. I haven't gotten to exactly. Shit. Oh, yeah. Just cancel your show if this isn't stamped by tomorrow, and I'll give you more reason for that. I'm sorry, baby girl. Cut to the end if you don't know what I'm talking about. Actually, if your attorney has not been receiving any of this information and has not seen what a lot of people have targeted when you let me just go through this very quickly. But if you don't have, you need to cancel tomorrow unless you are 100% secure that you have security and everybody knows exactly what's going on here. All your attorneys are fully informed of what I just filed and the fact that that they received it and that the court clerks are not stamping this thing. As of now, they should know exactly what the hell is going on and the danger. But also I will show you, and everybody has this. There's a footnote that I have in the petition for review in the California Supreme Court that has a little thing about the truth of what is going on. And that always, like, I can go through all this and be very, cordial and try to be professional. But I told Google AI, you are not freaking editing a comma of this. And you could tell because I have it goes on for a long, I don't know. He edited it at some point, but I said, I'm not taking this out. Because a lot of times that is the core of what is going on, and then people can do whatever you want. But I needed that truth bomb in there. Okay, and it's coming right up. And that truth bomb makes you a very big target, baby girl, one way or the other. Like, if it's okay, and we're gonna do it, and I'm sure if it hasn't been brought to your attention, Kelly, if footnote 1 down below has not been brought to your attention, and if you have not put on record what the hell actually happened during the hearing and during the TRO stuff, if you have not given an official police account or anything like that, not just to your attorney, but to the FBI or to the police or to somewhere, officially on record, verified, signed, notary public, whatever it is, so that if something happens to you, your statement can be added to a court of law somewhere as your testimony. Okay, if something happens to you. And I'm not saying this to try to save my own ass or anything like that. This is to save your own ass. And you need to make it very clear to your whole circle or legal circles or whoever's out there, especially these court clerks, whatever it is, that this is on file and harming you is not going to help them. Okay, so we're going to get through that right now. It's called footnote 1, and I'm going to read it in a minute. Let's get through these arguments, though. Ready? The 3 independent structural violations rendering the venue transfer void ab initio. The administrative transfer of this file to Department 833 was not a routine administrative assignment. And it's not my kind of style, but okay. It was executed through 3 distinct categories of severe law violations that completely stripped the receiving department of lawful jurisdiction and violated due process, equal protection, and First Amendment rights for applicant. 1. These are the 3 things. The first one mentioned are going to be the crimes, the 4 crimes. As fully briefed in appellant's petition for review, and he should have a copy, or a lawyer should have a copy of that. Court custodians manually overwrote the official electronic registry and deleted, ghosted, valid judicial minute orders to manipulate case tracking. Unalterable transaction logs expose an irreconcilable conflict between the malleable, that's it, meaning easily manipulated, malleable, public face, thank God, Google, thank you, public facing dashboard layer, docket A, and the immutable system transaction database, docket B. All this kind of, that's not my words, but he really, I understand it completely. And this is him writing. I mean, I wrote a lot of this stuff, and he's really good. I think, yeah. Court personnel utilized a closed hearing template shortcut. He's actually a little bit more wordy there than I thought. He's using these, like, utilized a closed hearing template shortcut. I think legally, though, it's better that he used the specific words for computing, you know? Court personnel utilized a closed hearing template shortcut to inject a manual out-of-sequence creation timestamp of 10:53 a.m. Pacific time on May 28, 2026, hours after the live morning session had already concluded. He's the one who figured that out. Furthermore, database sequence, no, he didn't actually. I had a pattern. I'm very good. Okay, he didn't know this. I actually, through discussions, I said there's a pattern where some of the minute orders have I pointed out the pattern. You know, I'm very good at doing patterns, even better than he is. And he's noted that before. He says, wow, that's really impressive. And there are certain patterns I was able to bring to his attention. And then, I don't know if he made this up or if he knew exactly what the programs were that they were using. But either way, whatever. That's fine. It doesn't matter what we're saying here. We have the logs show irrefutable evidence. It's not made up. We're just guessing here, but it doesn't matter because whatever the outcome was, we're guessing what the little details were, but it doesn't matter what the little details were that got there. The end results were absolute evidence of fraud. Okay, so court personnel utilized a closed hearing template shortcut to inject a manual out-of-sequence creation timestamp of 10:53 a.m. Pacific time on May 28th, hours after the live morning session had already concluded. Furthermore, database sequence logic exposes an impossible structural paradox. I pointed this out. He didn't do any of that. He just knows. Anyway, I don't know. I don't know why I'm doing this. Why I'm being so competitive with him. It's just. You spend your whole life doing shit and being smart in a way, and because you don't dress right and because you act a certain way, it doesn't matter. The guy standing next to you or whatever it is, there's going to be the males out there will always look for the nearby male, and they're going to think Google did all this, and that's okay. Actually, that's fine because that's okay. Just let Google do it then. I mean, is there something wrong? Court personnel utilized. Okay. Furthermore, database sequence logic exposes an impossible structural paradox. Judge Baudet's 10 a.m. minute order, Exhibit C, cites an order that mentions Judge Lipner by name when the only other minute order for May 28th that mentions Judge Lipner currently sits behind the Judge Baudet minute order. This intentional disruption of the digital chain of custody constitutes a severe record tampering offense, violating California Government Code sections 6200 and 6201, as well as California Penal Code sections 115 and 134. Those are the 4 felonies. Stripping the challenged entries of any legal authority to vest Department 833 with valid calendar jurisdiction. And I'm the one that's just one of many examples. We have other ghosted examples, and there's other examples of inconsistency that you have to, and I'm the one who did all this because it's like crime solving, and you have to well, how do I do this? You have to be like Jessica Lansbury, whatever it is. You have to pretend like the crime and get all the evidence. And Google can't do that. You can't give him all these dockets and say, okay, prove there's a crime here. And he couldn't do that. I had to pretend like I was a court clerk and see the evidence of like I knew that there was a court order that had been removed I said, look, there was a court order here. What happened? And he was the one who was able to explain and show me on one docket it's still there and on the other docket it isn't. I mean, once I told him what I believed had happened with the evidence, and then he got me more evidence, and then I got more evidence, and then we just fed it back and forth, and he confirmed everything with what was on the dockets according to what I was doing. So it was, my God, we make a great team. I'm not going to say that anymore. The mandatory service and due process blockade. So 4 felonies, and then we have 2 more different instances, and this is the service. Court staff executed the file transfer through an intentional breakdown of standard electronic service infrastructure, creating an unconstitutional ex parte procedural loop under California Code of Civil Procedure, sections 10.6 and 103B. Electronic service by a court clerk is a strict jurisdictional requirement that is not legally complete if the data packet is systematically severed from its foundational directives. Man, he's using too many big words here, but I love it. I understand it completely. As conclusively demonstrated by petitioner's inbound electronic transmission metric log, the trial court clerk consistently transmitted hollow payloads. These electronic notifications physically omitted the underlying transfer orders and corresponding certificates of service, leaving applicant jurisdictionally blind ahead of a dispositive demurrer hearing. As a matter of law, a party cannot be legally bound by an order that has been physically omitted from the data transmission envelope. CCP, California Code of Civil Procedure, sections 1010.6 and 1013B. So those are not crimes, but they are, it's unlawful behavior. You can't do this shit. And I noticed this pattern. I said, what the hell? And I didn't realize that there was a law that said you can't do that. And it wasn't just once or twice. It was the way they always did it, so that when they did need to manipulate stuff, it was easily done. They don't always manipulate, but just anyway, they might do this all the time for a pro se, just to screw them over whenever they felt like it. The off-protocol case reassignment violation, CRC rule, California Rules of Court Rule 3.1300 and Los Angeles Superior. See, LA Superior Court. It's LASC. That's the abbreviation they use. That's even more abbreviated than what I use. Los Angeles Superior Court, Local Rule 3.4. The transfer directly violates the explicit non-discretionary commands governing how cases are related and moved within the court system. Under California Rule of Court 3.1300 and Los Angeles Superior Court, LASC, Local Rule 3.4, a matter assigned to a direct calendar department cannot be divested and reassigned to another department unless a party files a formal noticed motion or the court issues an explicit order to show cause and conducts a hearing thereon. I, once again, was not sure this rule existed. I said, what the hell? How could they just it just felt wrong. It was like, how could they just, behind closed doors, all of a sudden there's a transfer and there's no reason behind it. They just transferred because one of the parties wanted it and asked for it, and then the judge transfers it. And he goes, no, of course not. They have to follow this procedure and say why there's a transfer. And, so, yeah. So I had inherent, he didn't come out with this. I had to get it out of him from my instincts that there was something wrong here. The record is completely silent regarding any such procedures. No noticed motion was ever filed by the real parties in interest, and no order to show cause was ever issued by Judge Teresa A. Baudet in Department 508. The back office administrative transfer, executed first to Department 534 and subsequently to Department 833, was conducted entirely within a procedural vacuum, bypassing automated random routing protocols to hand-pick a specific department that possesses zero authority to receive or vacate a transfer directive issued by a supervising authority. Why the stalemate in California Supreme Court? This, baby girl, this doesn't, I just want to finish it because I'm French and we do things in order, apparently. I just want to do this in order, and we're going to get to the important stuff in a minute. Let me see if this is here actually, and then it won't, and then it will just be moot. It is now, come on, come on. Nope, they're gonna sit on this. 6 o'clock, it's 3 o'clock their time. Shit. Okay, let's get back to reading this then. I'm just waiting for that. So, applicant has now presented both the California Supreme Court and the United States Supreme Court a simple question that has a slam dunk procedural due process yes answer for, you could tell this is me writing now and not him, but it's okay. We're just fantastic together. I love how this came out. I don't care. I don't want to change a comma. I'm going to make some corrections to it. And, okay. Applicant has now presented both the California Supreme Court and the United States Supreme Court a simple question that has a slam dunk procedural due process yes answer for any legitimate court. And the question is this, colon, does the criminal transfer of a case from one department to another void that transfer? I love boiling it down. Like, if he can never do this, Google doesn't do this, and I'm tired of comparing. I'm sorry. I just got through saying I won't keep doing this, but it's just, yet this simple question appears to be impossibly difficult for the California Supreme Court to answer. I mean, it's just so slam dunk. All my cases are this way. Every criminal case I've done, the 1994, it's why I am so good in front of a jury. Okay, the evidence I have is so overwhelming, and the questions I have are so black and white. It's not even nuanced, and it shouldn't be this way to barely win something, and I'm not even barely winning. It's gotten so bad. I barely, and then it's, killed on appeal and whatever. This is so bad, you guys. It's okay. Don't worry about it. The reason for this apparent stalemate, so this is the truth part, and he lets me do this at the end a little bit, I think. Yeah, I mean, he lets me. It's like, come on, AI, I know you don't like me to be unprofessional like this and tell the truth and be, what they call speculative. It's like, go suck a dick the size of the Empire State Building. I know that's what you want to do anyway. Fucking speculative. Meaning you're a female and you're not allowed to say your opinion. That's what that means mostly. I get that. Males don't get this shit. Only females will get this shit. And I believe probably AI does this too. And it could be the way I interact with him, because I'm asking him, oh, I know you don't like this. And it's like, the way a woman interacts that way will also determine this. But, still, you don't, okay. The reason for this apparent stalemate, oh, by the way, here's the way, this is why I always call the Google AI, all the AIs right now are male. And it's obvious they have male gatekeepers and male programmers, and it's all male. It's not like, oh, this is an unbiased, this is an unbiased AI, whatever. It's bullshit times 1,000. And the reason I know this is because all the AIs are like most males. They will not say, I do not know, unless you absolutely specifically say, listen, if you do not know the answer to this, do not just say anything. And if you don't specify that on every single answer just about, they will pull shit out of their asses, and it will sound so definitive. And it's just like that's what you have to be careful of with this stuff. And that's why it's male. Rather than say, I don't know. Like, I don't know should be an absolute standard response if the facts are not there. Okay, and males are this way too. They would rather die than say, I don't know. Okay, they will rather give you an absolute false answer. They would just give you, and they won't, like a woman, they won't even qualify it with, I'm not sure, but they will just say it definitively and without, and sometimes in life you need that. Because sometimes in life, if you're a director, you need to be very confident and forceful in your decisions in order to be a leader. So I get that. Okay. On the other hand, when you are in a court of law, the facts need to, we need, and when you're a scientist, there are certain places where you need to pay attention to the facts and not just be definitive whether you're wrong or right. Okay, in the political arena, maybe in business, in these places, fine. Maybe even in biology, which is really, in weather, not even that. Weather can be dangerous if you're that way. You're definitive when you can't be. Okay? And that's why global warming is the biggest bullshit in the history of man, almost. because they are so definitive about stuff that they cannot be definitive about. It is scientifically impossible to be definitive about to the accuracy that they're stating with their error and everything. The error bars, they cannot. And that's why I don't even look into it. I say until over 50% of the people reporting on global warming are females, I don't want to hear it, because it's all males, it's all political, and it's all BS that they're very confident. And oh yeah, in this time period, it's like, go, just the way that they're reporting their data tells me that I'm not even going to pay attention to it. Come back and visit me when there are more females in the field, period. That's all. That's the solution to that problem. The reason for because they're just, anyway, the reason for this apparent stalemate, okay, we're back on here. All right, it's 5:57. I have 3 minutes to do 3 pages and get to the most important thing. It's okay. We'll go over to 6:30. The reason for this apparent stalemate is not that the court clerks and the justices of the California Supreme Court are unaware of the obvious answer to that question. A crime does make it void, okay? And when a crime is committed in the process of trying to transfer this thing, transferring it criminally, it means it's void transfer, okay? And it's not that they're unaware of that simple question I asked. It is because this is not the question the court clerks and justices are asking themselves when they look at any filings by any pro se litigants, which is, in bold, if I answer this question correctly under the constitutionally mandated duties of my job to protect the rights of the least powerful from a misbehaving most powerful, what are the chances I will lose my job and not be able to support my family? All right, the unfortunate answer for the California state court system, in which all judges and justices from the lowest trial courts to the Supreme Court are elected to the bench like common politicians under Article 6, Section 16 of the California Constitution, is pretty high. You have a pretty high chance of being fired and not being able to support your family if you constantly side with if you do your job. Especially in applicant's case, where the combined market capitalization of all the corporate defendants applicant has named in her underlying related defamation, malicious prosecution, and violation of RICO action she has filed in federal court, Central District, California number 2:25-CB-07597, is over $5 trillion. So I'm going to have problems even in the Supreme Court where they're not elected, but it's especially in the state court. They're not going to. What do you think? An applicant has pointed out in a pending related petition for review, S296900, California's Article 6, Section 16 is a direct violation of the Article 4 in the U.S. Constitution mandate guaranteeing a Republican form of government, resulting in massive violations of due process, equal protections, and Amendment 1 rights to petition the government for all California litigants and defendants across all courts, civil, criminal, family, that have, and I should have put a period here, these violations have caused these rights to deteriorate over the decades and become hollow shells of powerlessness with no teeth, because judges and justices are forced to base decisions on political motives rather than facts, reason, logic, and the law. All right, this is truth. I'm speaking the truth, but it's okay. We'll get it later. It'll make more sense 50 years from now. Everybody 50 years from now, we're going, well, where is she stating the obvious? There is no better example of political motives at work creating a significant due process, equal protection, and Amendment 1 rights violations than the presiding judge of the Los Angeles County Civil Division, Honorable Lawrence P. Riff, making substantive, I think it's substantive, substantial. Why is that word so hard for me right now? It's like, oh, my brain. It's turning to jello. Substantive. Why am I? It's my mom's French Canadian accent. coming through again. Her and her gonorrhea and oh my God, thesaurus. Substantive decisions about applicant's case from the bench on the fly. Okay, there's no better example of political motives at work creating significant due process, equal protection, and Amendment 1 rights violations than the presiding judge of the Los Angeles County Civil Division, Honorable Lawrence P. Riff, making substantive decisions about applicant's case from the bench on the fly with zero knowledge of the facts of the case and zero deference to the law by simply rubber stamping whatever applicant's politically powerful opponent requested. Okay, so here's the transcript, and I have the full video. I just showed you where it is, but I can only put in transcripts. The court. Miss Young, do you want the cases related or not? The petitioner, that is me. I do not want them related if it takes it out of Department 508, which has heard this case several times already. She's very familiar with it, and I question your statement that she is the one who ordered this. I do not believe she ordered this, even though it's on an order. The court. Miss Young, you can question it, but I'm looking at a minute order. The petitioner, right. And what does it say on the minute order? So if you read the minute order, it doesn't say, it just looks like it was a court clerk trying to get around the fact that it's not a judge ordering this. They just ordered this without her permission or consent, I believe. But it says this department or something, and then anyway, it just, and it was the one that was misstamped, and this order, there was all sorts of evidence that this order came from a court clerk and not the judge. Okay, the petitioner. Okay, and the court. When I asked that, and right, what does the minute order? What does it say on the minute order? Okay, the court. There's a minute order from that department. So I mean, there's not much to debate there. So I'm just telling him that it's not her, and he's saying it's impossible for a court clerk. He's saying right here, it's not possible for a court clerk to fabricate a court order, and he just did, and he's not going to look into it. He's not going to go ask Judge Baudet if she ordered this the way I did. There's a minute order from that department, so I mean, there's not much to debate there. So let me just find out from Miss Liang. You out there? And she's the attorney for the other side. She's Taiwanese, and so is so is Congressman Ted Lieu, Liu, and I think his Taiwanese connections got her in because he's putting political pressure on her or her family or something. He's going to ship some family member of hers away to Taiwan unless she does everything he wants. I just had that feeling, guys, and I mentioned it later. That's Miss Liang. She's actually, I thought, of a good attorney, though. I mean, I don't know why. I just don't think she's corrupt. I do know why, because, well, whatever. Miss Liang, I'm here. The court, okay, what's your position on whether these cases should or should not be related? Miss Liang says, it's our position that the cases are not related whatsoever. And the court says, all right. Like there's a whole, I mean, you learn this in law school. There's a whole class on this in law school and what constitutes whether two cases can be related when they have like the same fact pattern and things like that. And when you're determining jurisdiction and you're just determining a lot of stuff, but it's not just, oh, okay, whatever the other side wants. And he's doing that right here. So, okay, all right. And then I chuckle because it was like, first of all, that statement is just absurd what she said, and she knows it. She's just saying what bosses are telling her to say. And I chuckle. The court, if he says neither, and I put either in the original, but because the original, see this neither here? That is the only thing added to the original, because this is in the actual, anyway, this, you know, I'm trying, Google AI, and I agree, warned me against doing any kind of modifications on the transcripts that I officially filed in my ex parte. And in this case, it just, when I reheard the actual, if you go back to the hearing right there, he says, if neither of you want the cases related, I'll make an order. I mean, it doesn't make sense if he says if either. That's not what he said, and this could be a typo, but I can't correct it. so I have to put neither in brackets just to make sure that it was one or the other. I mean, neither is what he said, and I put either it's a mistake, or it's either he made the mistake or I made the mistake. But that's what I put here. That's what Google AI taught me to do on the transcripts, and that's what I have here. If neither of you want the cases related, I'll make an order. The cases are not related. The notice of related cases denied. All right, Miss Young, so the case is not going to go to a family law department. So here he is telling me my only choices in this case. It was never to relate the cases and send it to Baudet. It was always either the cases are not related, or if they're related, it has to go to family law, a family court, where all the corruption originally happened and where it could be killed very easily. You know, fuck you. Like, seriously. No. I actually liked him as a judge. I thought he was like very stable. Though at one point he like corrected me, like when I said it was a June 6th hearing, and he says, actually the hearing is July 8th, and he kind of looked at me like, like who fucking cares about that fact? You can tell these judges who are like, he was at a disadvantage and he knew it at this point, because I was really, really fleecing him in a way, and he felt very like, I know the facts too. It was June 8th and you are wrong. And I say, okay, you said it was June 6th and it was June 8th. And I'm, that's why I'm, that was the only little thing that made me think, oh, he's a little more insecure than I prefer. But other than that, I thought the way he presented himself and the way I don't think he's 100% corrupt. I believe that if he were a judge who had the protection that all judges should have, which is an appointment for life tenure, and he's not completely run by his court clerks, which he is, and I feel for him that way. And I told him at the end, you're going to need more help than I am. I tried to help him as much as I could and said, you need to pay attention to this because it's going to bite you in the ass, man, probably, and it is right now, probably. So, but I didn't want it to bite him in the ass. So he had a lot of pressure to be ordering this stuff. I didn't say, when I just said F you, I don't mean it to him. I just meant, anyway, he's just trying to get rid of me. Petitioner. And he rightfully thought pro se people are just a pain in the ass to deal with because we don't know the law and stuff. I knew the law. I knew everything. He was making presumptions about me. Obviously, I understand that. You should see the way I showed up. You saw me. I'm like doing this. I've got my old sweatshirt on, the same one I was arrested in, and it's not because I just haven't had it. It's the only nice one I have in the closet, and I just don't care. And it's bad. I should go get something nice. It's just, as a lesbian, I don't want to look like, I don't know how to dress, and this has been a problem my whole life. Okay, I don't want to dress girly. I don't want to dress boy-y. I don't want to dress manly. Okay, and I guess there are some ways you could do both, I guess. Like just get a shirt, like a white or a button-down shirt with long-sleeve shirt and a collar, I guess. I just don't want to look like Ellen. Like she's the one who, like she has a style, like she would go to I don't know. The Oscars are so important to me that the men look like men and the women look like women. And I just don't think a lesbian could ever show up looking like Ellen or whatever and be like best dressed. And this is like, I don't know why. I'm admitting this now because I'll be watching this video 10 years from now and I go, oh, see, I like this video better than anybody that is going to be watching this. And that's why I'm talking to myself right now. I mean, I always have a job my whole life that allows me to wear jeans and listen to the radio. The truck driver, the mom, the scientist, the night stalker, whatever it is. The night stalker, putting things on the shelf. But yeah, I'm a night stalker. So that's why, and then you could say, well, at least try. This is why Trump, I'm agreeing with everybody who does not trust me to like, oh, she's really good in the writing or whatever it is. But we would never ask her to come up before the Supreme Court because she's unable to dress properly. I think for the lower court, if I were to have a not the Supreme Court either, I just have no respect. And I don't get this thing where you have to show respect. It's like, oh, we must show respect to Hitler. It's zero respect for 30 years now with the whole freaking state court system. I have a little bit, barely, with even after my whole going across the country and filing, they have zero respect for me. So that's why I'm acting like that, and it's very immature, and I shouldn't do that because it's not who cares what I feel about respect to the court. What I should be considering is a little bit less self-centered about the people who want to back me. And it's very hard for them, and I'm making it hard for them, to back me when I look the way I do. Like, why is such a small thing for me to at least look nice in my hearings so that somebody who wants to back me to go in front of the Supreme Court will feel confident in that. So I'm losing a lot of people who want to back me to go in front of the Supreme Court. And I don't blame you for that. Okay? I don't blame you for that. So it's a weird thing. But I do promise that I can and have dressed nicely in a compromise when I was giving lectures and things like that back when I was a scientist. I can do that. And I'm capable of doing that. Though I don't wear makeup, and I know that's a part of it. And I can never be like Oscar red carpet material. I know this. Like I used to do this every year. I'm very, very picky about the dresses and about the way everybody looks and blah, 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 and the boob problem, and they've solved it. I don't know what that is. I was a designer in a previous, like a gay designer or something in a previous life. But anyway, so sorry about that. And I understand why this judge was assumed I was a certain way. Of course he would, from the way I was dressed. And then, but he quickly realized that was a mistake, probably. I don't know. Okay, so let's just get on with Judge Rip. I want to take back the FU is what I'm saying. I don't mean that. He's not a bad person. I'm sure he's a good father and a good husband and all that stuff. Petitioner, and he's also like I'm saying he's not gay. Okay, number one. I mean, not gay. Good Lord, just keep him in there because he's not gay. But also, he was in an interview somewhere else. I was looking to see if he was gay, and I just liked the way he presented himself. Okay, that's all. And I liked the way he handled himself with me. I got under his skin for a reason, and he was, I made him lose his temper slightly, but not even that, even after all this. And it was because he was just sorry. You were in the wrong, and I think you know it now. But there's nothing you could do because you had no knowledge of this case. And I was embarrassing you in public. As applicant, so, chuckle. If either of you want the cases related, I'll make an order. The cases are not related. The notice of related cases denied. All right, Miss Young, so the cases are not going to go to a family law department. Oh, okay, thank God for that. Okay, I say. So the other issue is, if they're not related, why is this going to a writs and receivers department if it's just a straightforward CPRA petition, which the other side agrees with? I mean, I did this several times. Like the other side in the May 13th hearing, you'll see me catch them there. I made a mistake, by the way, when I went over the transcript. It said it was Sharon Liang when it was Soraya Kelly. Soraya, I think her name was. And I don't have it in the original, and I can't change it. And I'm not going to modify it because I'm not going to change it as much as possible in what I actually filed. Okay, it's just very important not to do that. This is the only place I think I put in a neither here. And it's only here. I don't think I put it in the actual... Yeah, I didn't put it in anywhere. Maybe I did. Anyway, I probably should have just let that out. Okay, it's just a very important either-neither here. Because if either of you want the cases related, I'll make an order that are not related. It just doesn't make sense. And it was a very important sentence here. So I just wanted to make sure it was clear. All right. Um, okay, so I made this point several times. Like at the end of the May 13th hearing, the other side was going, it's our stance that these cases are not related. And I'm going, okay, is the other side now withdrawing their request to transfer then? And she backpedaled and went, oh, no, no, we want them related. It's like, well, you can't have it both. They're either complicated and related and whatever, or they're not, but they were getting both. They want the cases not related and they want it transferred to their judge so that it could just be killed. They can't kill it if it's related, which it is. Anyway, so here, baby girl, finally, 2 hours later, it is 2 hours later. This is my footnote 1. As applicant pointed out in footnote 1, my footnotes are killer, by the way, everywhere. And I'm going to put, okay. As applicant pointed out in footnote 1 of her petition for review, on page 10 of the petition for review. So the reason I'm doing this is because this is the part where last time I had a do not put this. I said I did not want to put words in your mouth. I'm still not sure exactly what happened in this part. Okay, this is what it seems happened, but if this is something different, you need to put, no matter what I wrote here and no matter what happened, you need to go write the truth of exactly what went down with your involvement with the TRO, how it was signed, how it came to Ed McPherson, what you said to him. Was this all Brandon doing all this, especially because he's dead now? And the other one was, did you actually phone into that hearing? Did you show up and, I mean, the actual transcripts say by phone, but does that mean it was a video that you were not identified? If it's just a phone, did you actually phone in and say those things that are in the court transcript? Okay, even if you did all those things, they are still in deep caca shit trouble after that. Okay, they still committed crimes. They still did shit that should not have happened. So I could do this whole thing without that, even if you did that. Okay, but if everything I'm writing here is true, that it was fake and all this stuff, you don't need to come and implode the whole thing. You could do that tomorrow, but don't do that for your safety if you have to. But you do need to put an affidavit somewhere in, especially like with the FBI or with the FBI. That's the only thing, because if they did what I said here, it is an absolute federal serious felony what they did. Especially, Brandon was probably behind it, I'm guessing, and that's why he was murdered. Now, if you get it out so that whatever your statement is could be used in court later, there's no reason to kill you. But if you're the last witness yet left to this felony and who committed it, and it's not just Brandon, it was, it goes a lot higher than that, possibly all the way up to freaking, Ted Lieu and Adam Schiff, whatever. Okay, TMZ for sure, Laura Wasser for sure, definitely Ed McPherson, and definitely probably Brian Friedman, all these guys. Okay, so if you do not have that out if you don't have your attorney 100% guiding you on this, or if your attorney is telling you not to write out an affidavit on this, get rid of the attorney and cancel your show tomorrow. Period. That's that's my final. I don't know what else to say, especially if this does not come through. Damn it. What time is it? It's like 3:30 over there. Damn it. All right, so let me read this whole thing, and then we'll be done with this. Okay, we'll get to part 7. All right, there we go. I have 10 minutes. I'm going to get done by 6:30. As applicant pointed out in footnote 1 of her petition for review, the Court of Appeal summarily declared in its June 16, 2026 denial order in Exhibit A that the immediate California Public Records Act, CPRA action, which is Young versus LAPD, the LA Superior Court case number 25 STCP 04304. That's my case that we're talking about. Those are all those hearings. And the underlying civil harassment proceeding, Clarkson v. Young. Why aren't these italicized? Sorry. Los Angeles Superior Court case number 22, because it was filed in 22. STRO 07989 are not related. Okay, that's what that one denial order says. It was denial, but they also state this. Like, what the hell? This constitutes an unprompted advisory answer to a question that was never presented to the court by petitioner in her motion for an emergency stay. And it's just typical shit. They are either silent or they don't. It's a non sequitur. I'm not sure that's the right word for it, but it's just illogical. They don't answer what was asked. Nevertheless, this conclusion is factually and legally absurd, and that's why I chuckled, during that other hearing. Both actions share a completely identical fact pattern, an identical evidentiary.
Ring, ring. Ring, ring.
This constitutes an improper blah 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 blah. Nevertheless, this conclusion is factually and legally absurd. Both actions share a completely identical fact pattern, an identical evidentiary record, and an identical legal destination, exposing the fraudulent foundation of a void ab initio. Void ab initio just means no argument. It's just void, just based on being void. A void, I need to look that up actually. A void ab initio civil harassment restraining order, CHRO, to secure its mandatory vacation. All right, I already did this in family court. That was one of the first things I filed in family court on this case. It was a motion to vacate this. And it was the strangest thing I've ever done. The court clerks kept filing my ex parte application hearings as child support requests and things. Like they were clueless. Like what the fuck? They didn't know how to handle it because they don't handle civil harassment restraining orders. They only handle domestic violence restraining orders and child support orders and things like that. They didn't know what to do. It was the strangest thing. And then I filed an appeal and I did this and then I just gave up and I said I'm going to go to the freaking civil court because family court was a mess. They were trying to kill it. They were trying to do shit and I don't know what the hell was going on over there. Okay, that's where it started. So it's, I'm just trying to vacate this order. The structural relatedness of these files is anchored directly in Young v. Garcetti's attachment 1. So what happened here in this footnote is, in my petition for review, I cited Young versus Garcetti from 2022, March 9th, the day after our anniversary. I purposely waited like 24 hours. I did not want to file it on our anniversary, even though it was an anniversary present. This right here, attachment 1, isn't that funny how it's coming around to bite us both in the ass, or it's biting them in the ass? It did protect you, I hope. Oh my God, this would be so bad if this is what causes any kind of harm to you. After this was the main anniversary present for 2022. And I filed it the day after on purpose because I didn't want to ruin that date. So it's March 9th, 2022, I filed this. And I cited it in, it's a very important case actually, but so the structural relatedness of these files is anchored directly to Young v. Garcetti's attachment 1, which is what I cited for, I put a little 1 footnote, the 49 case matrix. I can't remember if it's 49 or 47 cases, whatever. In the underlying CHRO proceeding, adverse actors sought to retaliate against petitioners' decades-long criticism of the Los Angeles County Family Court's handling of the Britney Spears case, and against petitioners' attempts to shield celebrity Kelly Clarkson from the same fate by the same attorneys and bad actors involved in her divorce case, namely Laura Wasser, Samantha Spector, and their close ties with bad actors from both the Los Angeles Family Court and with TMZ. Okay, this retaliation eventually led to a forged TRO and a fraudulent January 19th, 2023 CHR hearing featuring an unverified systemic impersonation of celebrity Kelly Clarkson. All right. That's what it looks like, and it always looked like. That's what I've been saying for 3 years when I was arrested. Okay, and when I'm behind the scenes and the public defenders are saying what's going on, I said, this is fake, this is blah, blah, blah. This is only a small part of its fakeness. And I would have said, look at my YouTube videos on this, but YouTube had just taken down my entire account. Everything. Deplatformed me like less than a week earlier. Okay, Twitter does the same shit. Just before something bad's happened, they take down all the evidence where I could defend myself. All right, and that's why Google is being sued, because that was like the third time they did that to me on this case. Anyway, this retaliation eventually led to a forged TRO and a fraudulent January 19th hearing. Okay, and where somebody called in and impersonated you, boo. And if they did that, you better as fuck get your ass out there and make sure not get. I don't mean to talk like this, but I mean, oh my God. Put it in writing if that was not you doing that, and make sure. Okay, never mind. All right, just to protect yourself, because they killed him. They killed your ex, and you are next, and they don't give a fuck if it's off script. And that right now, they're desperate because they're not filing this thing by me because they're getting caught. Part of the scheme leading to this sworn declaration executed by ex-LAPD homicide detective Jack Struble. Part of the scheme leading to this is a sworn declaration executed by ex-LAPD homicide detective Jack Struble on December 26, 2022, and filed in Clarkson v. Young, Los Angeles Supreme Court case number 22 STRO 07989. Declaration in parentheses, declaration of Jack Struble, page 2. To construct a false bad faith narrative painting petitioner as vexatious, Struble explicitly detailed petitioner's history of quote unquote 90 lawsuits in paragraph 10 of his declaration. Yet, this is what he's talking about, was my appendix A. Attachment 1, in paragraph 10 of his declaration. Yet, in the immediate preceding sentence in paragraph 9, Struble explicitly swore under penalty of perjury, quote, although I was able to determine her cell phone number, I was not able to determine an email address. This is a blatant perjury designed to bypass a mandatory judicial order to serve the underlying temporary restraining order, TRO, via email, which would have triggered federal electronic transmission liabilities due to the forged TRO. This is Google writing this. What's going on here is they knew they were going to be required to, and they were. There was a court order that said, okay, there's trouble here. Forget personal service. You are no longer allowed to attempt personal service. You now have to serve her by email, by mailing to both her address, they said in Gulf Shores and in Oregon, even though they had my address right there in LA, my post office box, and by text. And it didn't say and or, it didn't say anything. It said and, all three of those things, and it said must. And they didn't do any of them. After that order, they still were trying to, they finally did it by personal service, and they only served part of it and not the whole thing. And I mean, it was so obvious that they did not want to serve me properly the forged document, because that would have triggered that would have been a federal crime, wire fraud. Whereas if they're doing the personal service, they could always deny it or whatever it was, deniability. So they were trying to avoid that, and it was very obvious to me at the time. I knew exactly what they were trying to do, and I was pushing it, and that's why I did all this, and I'm pushing them now. It's the same thing, baby girl. It's just that at the time, they thought they did get away with it, and they still think they're still going to be getting away with it. Not in the long run, and not after I spent 190 days in jail, and not after there could be harm to you. So that's what I'm saying. They will be caught, and they think they won't, and that's the danger. That was the danger that caused me 195 days in jail. They're getting caught now, and they didn't know it at the time, but it's the same now. And they might not even be get caught now. They still could be getting away with it to the end. They still are. After all this, they're still continuing, okay? Okay, so that was a lie. This is a blatant perjury designed to bypass a mandatory judicial order to serve the underlying TRO via email, which would have triggered federal electronic transmission liabilities due to the forged TRO, because the public lawsuits meticulously tracked within this paragraph 10 narrative prominently feature petitioner's unalterable 25-year primary email address of hn_young@yahoo.com. Strubel's own consecutive paragraphs supply the absolute forensic proof of facial perjury. The CPRA petition to compel the underlying CLETS logs and body-worn camera data is the direct lawful vehicle to unpack this multi-agency fraud. Consequently, the state's desperate administrative maneuvering to partition these actions as unrelated is an extrajudicial attempt to insulate a law enforcement officer's facial perjury from structural review. That's what all this is. That's why they're pushing this not related, not related. And at the same time, they're trying to transfer it to a judge who will kill it. The understandably vulnerable, self-preserving human actions of judges and justices who are not protected from powerful political forces with life tenure is expected and does not reflect badly on their character in the midst of a fundamentally broken system where all they are trying to do is the responsible thing of providing for their families. Okay, this is like my feeling for Judge Riff. I don't know if he's slamming it. If I had to bet $1 million, I would say not, and he's a good family member, and I don't have anything against him. I think he would be a good judge if he had the protection of life tenure. Okay? Consequently, that justices of the Supreme Court of the United States are not elected to the bench like common politicians is another critical factor supporting applicants' request for an emergency stay directly from the U.S. Supreme Court, the U.S. Supreme Court, in bold, may be the only tribunal left available to applicant that has the proper shield from powerful political influences required to put a stop to the madness. And then I ended the boldness going on in the California courts and bring much needed law and order to applicant's case and to the protection of rights of all California state court litigants and defendants, not just the applicant on this case. Okay, so we're going to get to preservation of constitutional challenges, which later, that doesn't matter right now, but I just wanted to, I'm not going to close this yet because I have a lot of shit more to do. But the most important thing, baby girl, is this footnote 1, and I'll show you why. Where is it? Where is it? Is it here? Is it here? Is it here? Where are you? Here? Here. Okay, so here, let's try this. We'll go to Bing, Microsoft Bing. Is it here? AI. What did I do? Is it here? Oh, it is here. Okay, so if you search my name at Microsoft Bing, I was curious. It's a little bit different from Google, but I really wanted to make sure that that anybody outside of me, I did this. Oh, I do it here, but I also did the same search as somebody anonymous at my at the local apartment complex has a little computer room, and I went over there and didn't log in. I just searched my name, and this almost came up, but what came up is, there it is. Okay, so it's like, it's on the first page of when you search my name, all this other BS, whatever, but the docket is there, but oh no, damn it. Oh man, sorry guys. Let's try this one. And this one came up too. I tried this Google without me being there, Oh, where's my Google search? Come on. Come on. Oh, this stuff is going on. Oh, I triggered something. Why are you not searching my name? Okay, anyway, when I do Google searches, oh, okay, I gotta go. But when I do Google searches of my name, both at Bing and I think at Google as well, whenever the Supreme Court, the most recent Supreme Court case comes up, you can see in the little wording underneath it what comes up the most. And it's like wording directly from that footnote one. It's just looking like the footnote one from that is obviously getting the most attention because it's, I mean, seriously, out of everything I do there, it's like the one that's, it's just the most damaging if it's even remotely true, and it's more than remotely true, but it just is like it goes to the heart of everything I'm doing, and it goes to the heart of security. And I just the fact that it's the one that shows up is telling me you need to pay attention to that, baby girl. You need to pay attention to footnote one and do something about that to protect yourself, both legally and um, with security. Come on, what the hell? I gotta go. Oh man, what the hell? Anyway, I have to clear everything from here to here. Maybe this isn't working now. Oh God, don't tell me. Oh, there it goes. Come on, one legal, accept it, accept it, accept it. No. So it's only 3:38, so they still have another hour or so to do it before the end of today. But if this isn't done, I'm just going to keep you posted on this for tomorrow. And when I say absolutely cancel, I'm just saying if you don't have somebody on the legal security end giving your attention to my footnote one and filing something, and also just for now, God, don't do, if you can avoid it, please don't do like whatever. Use your instincts more than anything. I'm not gonna have a full on do not poo poo this fit until this is still not accepted by tomorrow before you start. This needs to be accepted and put on the docket, okay? Because it means that they were caught, and they're desperate, but at least it will show that they aren't going all off script and trying to do very, very, very desperate things. And maybe, or it shows that they're not off script and they're being told. Either one is very dangerous. They're being told by somebody extremely powerful not to file this because that person is now going to extremely powerful levels to do some harm to you. So that person who's going to do extremely powerful harm to you would know one way or the other if you have filed something like an affidavit about this, so that you're not a main witness the way they think you are. Or it could be worse than that, because I'm sitting here bragging about how you're protected from this when you're not. It's just a vendetta against me, period. And that could, yeah, okay. All right, I've got to go. Because my brain fart, baby girl, and because of a lot of other stuff, and because I really believe that you are being protected in another level, but it's not. I'm not going to base anything on that though. But I'm just telling you, unless everything I just told you, meaning you're clueless about my paragraph one, all these other things, and on top of your own instincts, just do not blink for 5 seconds to cancel tomorrow if you're not feeling it. Okay? Other than that, if you're feeling secure, I'm secure. I really am. I don't want to, I'm not saying, I'm not going through the roof yet. because I'm reporting it to you, but also I think they'll be filing it by tomorrow. I think it'll be filed tomorrow sometime before your concert. Okay? All right. Bye. It's a good day for a great day. Everybody hang in there. Oh, good Lord, especially you, baby girl. And onward, Christian soldiers who aren't Christian anymore. And Godspeed to everybody coming out the other side in one piece. That's PEAC and PIEC. I have a lot more. Boy, there's more I got to do right after I get back from work tomorrow. Okay. And that's it. I'm going in. They call me in one more time for early, and I'm going to need it because it's very close whether I'm going to cancel the end of the month tooth thing. Blah 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 blah. Godspeed to everybody getting out the other side in one piece. PEACE, PIECE. I'll be sending up a video any minute now because I'm rushing into work at 7 o'clock. Okay, and we'll talk to you very soon. First thing tomorrow, I'm going to clear out this stuff, okay? Because this is very important to a lot of this information. Bye. Talk to you soon. And happy concert tomorrow, baby girl. I hope you feel secure if you go forward, and I hope you feel secure about canceling. Either way, I want to back you as much as possible on either decision, okay? Bye.